Hello and welcome to Law and Society. So, this is, you can call this a third installment of the Colorado Supreme Court's decision. In the deep dive, I left out justiciability because justiciability is kind of a parallel ancillary um, topic that that is the rationale as to why this court or why a court uh, can or should not hear a case beyond the jurisdictional requirements. So, if you're new to my channel, please like and subscribe, and let's dive into it. I'm going to read you the opinion, and the opinion does quite a good job of explaining what justiciability is. So, here we go. A controversy involves a non justiciable political question when there is a textually demonstrable constitutional commitment of the issue to a coordinate political department, meaning legislative, executive, or a lack of judicially discoverable and manageable standards for resolving it. So, that is sort of the test that is applied when somebody brings up the political question justiciability issue. So justiciability includes other things like ripeness and standing and a few other political questions that are not relevant in this case, that are cases that uh, judges can and courts can in their discretion say that it's it's not justiciable because it's a political question. It's not justiciable because the person bringing the suit doesn't have the right to bring the suit standing. It's not justiciable because it's unripe. The case has not it's not realized fully yet. So the Colorado Supreme Court has cleared in the first part in the election code that uh, the state's interest here uh, is and the elector's interest here, it has standing, and the ripeness of it is so much so that January 4th, 2024 is when the deadline for Colorado's uh, Republican presidential primary ballot is certified. So uh, it is ripe to be considered whether this person is qualified or not. And then President Trump asserts that presidential disqualification under Section 3 presents a non-justiciable political question. So the court disagrees and says that the political question doctrine is a narrow exception to this rule, that the judiciary has a responsibility to decide cases properly before it, even those it would gladly avoid. So a court may not avoid its responsibility to decide a case merely because it has political implications. And then it presents the test. The controversy involves a non-justiciable political question when there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. And then and then it goes into breaking down those required elements. The requisite textual commitment must be prominent on the surface of any case. Trump argues that the case is non justiciable because, in his view, the Constitution and federal law commit the question of qualifications of a presidential candidate to Congress. However, uh, that's not so the case. And so the court goes into explaining what um, is the actual case. We perceive no constitutional provision that reflects a textually demonstrable commitment to Congress of the authority to assess presidential candidate qualifications. So, and then it talks about the different sections uh, in which this the question comes up uh, of commitment of Congress's commitment to qualify a presidential candidate falls on Congress. It says that it doesn't say that. So then the court says Article 2, Section 1, Clause 2 of the Constitution empowers state legislatures to direct how presidential electors are appointed. And the Supreme Court has recognized that this provision affords the states far reaching authority over presidential electors absent some other constitutional constraint. In furtherance of this delegation of authority, the state has evolved comprehensive and, in many respects, complex election codes regulating in most substantial ways with respect to both federal and state elections, the selection and qualification of candidates, among other things. The election code, as it pertains in this case, is an example of such a comprehensive code to regulate state and federal elections. In fact, Article 2, Section 1 does not undermine the substantial authority provided to states to regulate state and federal elections, uh, which is, determines the time for choosing electors. Then the court says, in this court's view, in our view, Section 3 text is fully consistent with our conclusion that the Constitution has not committed the matter of presidential candidate qualification to Congress. If Congress were authorized to decide by a simple majority that a candidate is qualified under Section 3, as President Trump asserts, then it would nullify Section 3's supermajority requirement when it comes to curing the disqualification. Because Congress has been given the power to remove the disability by 2/3 vote. It hasn't been given the power to qualify the candidate. This provision, however, says nothing. So then there are other sections that Donald Trump brings up, like Article 2, Section 1, Clause 5, about the qualification of the president. And the court says this provision, however, says nothing about who or which branch should determine whether a candidate satisfied the qualification criteria. Nothing in the 12th Amendment vests the Electoral College with the power to determine the eligibility of a presidential candidate. Then goes on to say that nor does Section 5 of the 14th Amendment delegate to Congress authority to determine the qualifications of presidential candidate to hold office. Moreover, the amendment says, so here we have 20th Amendment, Section 3, is another example that the amendment says nothing of who determines in the first instance whether the president and vice president are qualified. So there is no commitment to another branch, is what this court is trying to say. Trying to say that no other political department has this jurisdiction. This has been vested this power to determine who is qualified or not. For these reasons, the court says, we perceive no textually demonstrable constitutional commitment to Congress of the authority to assess presidential candidate qualifications. So then it says that, then it goes into the second test of it. The lack of judicially manageable standards may strengthen the conclusion that there is a textually demonstrable commitment to a coordinate branch. So Section 3 disqualifies from certain delineated office persons who have taken the oath to support the Constitution of the United States as an officer of the United States and who have thereafter engaged in insurrection or rebellion. Although as we have discussed below, the meaning of some of these terms may not necessarily be precise, we can discern their meaning using familiar principles of constitutional interpretation, such as careful examination of the textual, structural, and historical evidence put forward by the parties. In our view, declining to decide an issue simply because it requires us to address difficult and weighty questions of constitutional interpretation would create a slippery slope that would lead to a prohibited dereliction of our constitutional duty to adjudicate cases that are properly before us. So the court says that Section 3 involves judicially discoverable and manageable standards. So I wanted to bring this out to you and show you that. So that's pretty much it about the substance of it. So what I want to tell you now is that justiciability is often one of the things that the Supreme Court uses to, and standing being just part of it, one of them uses to sidestep the substantive issue. But in this opinion, the Colorado Supreme Court clarifies the standing issue in the very beginning with the electors and how the code, and then in the justiciability of Section 3, it says that it's not committed to any other department, and it is the matters are judicially manageable. And if they are judicially manageable, only if they're not judicially manageable can someone conclude that it is in some other branch. And in this case, we don't see that. The Colorado Supreme Court says, and because Section 3 points out exactly what they meant when they were talking about who is disqualified. And then it can be discerned from constitutional interpretation and then historical record and textual structural evidence. And therefore, because it has not been committed to another branch, and because it has these ways to manage the case judicially, the Supreme Court says, because we don't see it being enunciated anywhere else, we have to take it. We have to take the job of interpreting this because it's not committed to another branch, and so making it a question that is ripe for judicial review, so to speak. So obviously, the Supreme Court of Colorado knew this case was going to go to the Supreme Court of the United States. So with that, that's the regular part. I see that there's a question, book Bewitched. Let me see if there are any questions, if I can answer them. So I apologize that you read the Constitution and find it, are confused about it. But what I want to say is that the way that the Section 3 is written and you understood it, that's great. Section 3 of the 14th Amendment gives, in the case of justiciability, it gives the court enough to create judicial standards and interpret that section through historical context and factual structural evidence that that sort of buttresses the ratification, the drafting and ratification of Section 3 of the 14th Amendment. So the, what the Supreme Court of Colorado is saying in this instance is that because it is the Constitution gives us this provision, and nowhere does it say who determines the qualification of whether a candidate can be president or not, that by the nature of not being handled by another political department falls upon judicial review to interpret and deliver an opinion. So that procedural part is often how high courts, and this court pointed it out because it's a difficult, weighty issue. A lot of courts will say, "Oh, it's a political question. It's non-justiciable. It's weighty," and so this court says, because it's a weighty political question or constitutional question about a constitutional provision, that shouldn't, because it's weighty, shouldn't stop us from looking at this case and ruling on this case. In fact, the lack of having other political departments in charge of who seeks qualifications, states have taken on that responsibility. And that's exactly what the election code in this case is about. It is specifically that qualification standards that the states have imposed because no other department has it. And because states have imposed these laws, it is up to judicial review to the state courts, and the state courts have jurisdiction over them, and the Colorado Supreme Court has jurisdiction over them. So, looking at, as if you've asked, going to your question, this recitation of the Section 3 goes to showing that there are manageable standards by which the court can assess this case and interpret the Constitution as it applies to this case. So I don't see any other questions. And thank you so much for being here. If there is anything else that comes up, I will come back and discuss. Please remember to like and subscribe and share. It helps me out a lot.